Thank you very much. It's really pleasure to come to India. I start with a story. Last month I was in Chennai and I was in the airport. So Mr. Tariq Khan's luggage delayed and I went outside. I was sitting and two gentlemen approached me from India, from the local people. When Tariq, after half an hour come, he freaked out. I said, who are they? But for me, they were very friendly. They came and they talked about, they lived in UAE. They talked about the foods, about that. They worked in UAE and they were talking about their experience. So we saw the culture is too closer to each other. So that's why I was not feeling intimidated. If I was in another city like London, I would be really freaking out, two people coming closer to me to start conversation. But India is a different. And then they told me something interesting. You wear a longi under your kandora similar to us. It's our longi. I said, yes, it's your longi. So they told me that. Now, the problem is in the life, what happened when fair for you is a different than fair with me. When a Marathi gentleman in a business transaction come and shake hands, mean for him, maybe tomorrow we can take it seriously. But for you, coming from other country, means the deal is done. That is a difference where the culture difference comes. Inshallah, for example, in UAE, God will be doing something. It doesn't. For other people, inshallah mean done deal. Now, there is a culture difference between all of us. And the culture is a huge risk and it's a product. But we view the culture, it's something nice. We'll have a same food, different food. But it is not. It's beyond that. Let me give you some example. I was younger version of me. I didn't have a gray hair. I was working as a company secretary for a telecom company. So it was new second operator called Do Telecom. Some of you could know. And then what happened one day, the CEO is a French citizen and the chairman is a Marathi. So they were sitting at night, 1 month to launch the service. So the chairman told the CEO, why don't you do a number launching campaign? People book their same number. So if you have 050-1111 اتصالات, you can say 055-1111. And I saw the face of the French guy was like, he kept silent. And then we went to office. After 2 days, he said, what is this? The chairman is calling me about this. I have many things. The network is not working. Nothing is working. And that I'm a 1 month I have. And now what is this number campaign? So he asked me, do you care to book your number? I was like, okay, if I say no, offending the chairman. If I said yes, so basically So I did the smart thing. I said to the CEO, I really don't care like you, but my wife and brother and sister, they care. And my mother cares. So he said, okay, call the team. We called the team and everything, and they did number launching campaign. And then the team, when they came, some Emirati say, yeah, by the way, Emirati cares about their number. They identify in our culture with the numbers. Car number plate is important. Telephone number plate is important. You don't want somebody calling you by mistake and you give him, no, it's a wrong number. So they want. So what they have done number campaign. Within 15 days, we have registered 500,000 people. Within any operation, they did 75 million dirham, $20 million. No operation, no anything. Just literally knowing the culture, transforming the culture from something we hear about to product. Now, let's see how the culture can make a crisis as well. So, anyway, the CEO was so excited. He said 15 days we will launch and we have 75 million in our bank for the chairman. And he said, chairman, how are you going to hand over for them the SIM card? He said, we give options for people. Either we send it by PO box, to PO box or by post, or you can collect it from the office. The chairman looking to the CEO. He said, so the CEO thought, I'm the man. You're saying you are the man. But he didn't mean that. He means something else. So after 15 days, day 31, 95% of the people doesn't trust mail service in UAE. And always in their back of mind, somebody will store their number and their bill they will be responsible. So we had roughly 100,000 people on our shops, and we had only 10 outlets, and everybody was. So it was the first crisis because of the culture, misunderstanding the culture. So what happened is then the chairman said, I told you. The chairman, the CEO said, no, you said, you're a good man, you are the man. I said, he looked to me, so why didn't you tell him when Emirati do that you screwed up? So basically, and that's same thing. If you go to the street, like my wife, when if you ask her about what is arbitration, she would say it's a process, fast, alternative to the court, flexible. Is that true definition of arbitration today? It's not. Because today in UAE, Tariq will tell you, we have the court which is faster than arbitration. Cost-wise, court are cheaper than, or less expensive, I would say, appropriate word than arbitration. In, for example, Dubai court, 95% of the case will finish in 8 months. And most of the case in Dubai court, because it's civil jurisdiction, it's on submission. There is no oral argument. So basically, the judge, upon the document, there is no disclosure. So basically, it's a faster. Cost is cheaper. But what distinguishes arbitration? There is, as I said, culture complexity, frustration. Arbitration is the only venue they were understanding. When we choose the arbitrator, we don't choose because he's the best lawyer's legal mind. We choose him because he interprets the culture. He would give the understanding of the law. In my practice, I have seen English lawyer, Indian lawyer, coming when we see same article of civil law. His understanding is different. He could see element in the law that we cannot see it. We cannot appreciate it. So that is the first important element of arbitration. We interpret the law and we understand the law. Then the process by itself, it's a cultural artifact. It's a human-centric. For example, in a courtroom, you cannot say to the judge, by the way, I have to go prayer. But in arbitration, we understand that. In arbitration, when arbitrator tell you, tomorrow is a graduation of my son, the other colleague would say, okay, let's have a break. In arbitration, other than why it's a human-centric. In my experience, I was sole arbitrator in a case, and I have this American lawyer, counsel, arguing so aggressively. The case was small case in the volume between those two companies. But the way he aggressively argued, started to laugh on the witness, one of CFO of the company. The relationship was destroyed, not because of arbitration. And later on, I meet the lawyer, the counsel of respondent. He said, we came to arbitration because we want to preserve the relationship. But because of this counsel of claimant, because then the owner of the company said, we will never ever deal after humiliating us by the counsel. So it's all about the cultural understanding. It's a mechanism built for cultural understanding. It's not anymore about fast, confidential and all of that. There is a unique thing in that. One of my clients' recent experience was telling me, he went to Cayman Island court, and he said he felt the judge didn't take him seriously, being Emirati, Muslim and Arab, and in his award say, the more credible is the English witness. Why? Because my client, I told him it was not about the judge being biased. It could be because culturally you were not able to express yourself. In contrast to arbitrator, for example, in India and UK, you sit and deal mostly with the Indian clients with English judges. But in arbitration, we know all culture. We know the accents. I have Arabic accent. You have Indian accent. We are used to know what is the culture, what is the value. But when in the court, the client said it, and it was right when I read the judgment, because the judge didn't understand him. He never heard Emirati speaking. He didn't know that they are loud, expressive, using their hand and all of that. He felt the other one was quiet, silently speaking, good English, that is good, but would never ever happen to arbitration. Arbitration is not about who knows about the law, who understands the law and understand culture. I don't want to make it longer because His Excellency Justice is here, and it's an honor to be here with him today. Thank you very much.
Concerned or daunted by the fact that I'm carrying some papers with me or a computer. The principle of speaking to public anywhere is, especially in courts or for lawyers now, for me especially, is be brief, be bold, and be gone. That's in today's, as you've commanded. After the brilliant speech by, a brilliant perspective of lawyers and arbitrators from the Middle East and people from different cultures. It is true what he says, and I fully agree with the manner he said it. There was no aggression in what he said. I'm not making a commentary, but look at the beauty with which he conveyed it. We, fortunately in India, Mr. Hussain, we have people for a huge subcontinent. We have different types of cultures, if I may say, in the south and the north and the east. And so we have a fabulous melange of people coming from different backgrounds, and we are used to that. Some aggressive, some polite. So in the court, it was always to counsel, at least I followed that. Do you want me to hear you, or do you want me to listen to you? In arbitration, there's no space for theater or theatrics. You're there to persuade the mind to see your point of view. And largely, actually, the papers speak for themselves if there's no oral evidence. So I think lawyers from here and people who've been on the bench or who've done adjudication, they are fairly used to these things. It's people who are otherwise not exposed to much wider cultures, much more accommodative cultures. And you mentioned some of those who are facing, who feel out of place. In fact, they're having difficulty in having those protests as of yesterday. So, having said that, how do we resolve cross-border disputes? And I'll come to the act itself, which is being talked about here. And very briefly, in about 10 sentences, this MSME Act of 2006, 20 years ago, it's a brilliant act, truly brilliant. It empowers those who are not so strong to face the larger players in the industry and the economy. You know, a figure on the internet said that roughly 10.7 lakh crores is money stuck in delayed payments. Now ask yourself as a businessman, the average cost of finance, cost of borrowing of money is 10 rupees or 10% or 14%. 10% निकाल के देखिए कितना होता है 10 लाख 11 लाख करोड़ का 1,10,000 crore annually. Sorry, Mr. Hussain, I lapse into Hindustani. Okay, so I do normally lapse into Hindustani. It makes it more conversational. Fantastic, thank you. So look at the figures, and who are the ones who are suffering in this if their money is delayed? The ones who have set up a unit for, say, 2.5 crores with a turnover of up to 10 crores. That's a micro. Then you come to a small and you come to the medium. Maximum it's up to 500 crores is the turnover and with 125 crores investment. This segment of our economy is the backbone, especially for India. It's for other countries as well, but for India, this is the most important. And they are the ones who often run into trouble. And that's where lawyers and legal experts have to hold their hand and steer them. Aise kar sakte hain. Let's move this way. The act actually empowers them in many ways. If you don't pay the money within 45 days, you have to pay thrice the RBI rate. Any sensible person will say, "Bhaiya, paisa de do, 3 guna pe sirf interest dena padega." And within 45 days, if you don't do that, you go into to the facilitation center. 15 din mein nahi hua, you're going to go into arbitration. But the arbitrator will keep in mind that statutorily there are 3 times interest dena padega. Usi mein sara qissa khatm ho gaya. Yet, despite all this, look at the figures that the Samadhan portal has to speak about. Just let me read the figures. As of last year, or latest figures, 96,560 cases were filed, and they're on the portal. The value is 27,000, say 28,000 crores. It's the value of those cases. How many cases were disposed of in the last few years? 50,000 cases. But this one still remains for a value of approximately 8,000 crores. So how many applications were filed? 2.5 lakh crore rupees. 2.5 lakh crore applications were filed. See the amount of disquiet there is within the industry. These are figures for lawyers to think about. For a center like this to be actually looking forward, going ahead and saying, look here, we are here to assist you. Most of the time, these small players, they don't know the powers that they've been enabled by a particular act. The person who owes you money cannot show the interest as business expense. Uski जेब से जाएगा वो पैसा. If there's an arbitral award or a settlement which will be deemed as an award, you have to then deposit 75% of that money before you go under Section 34. There's no appeal, unlike the other ones. So there's special protection for this. The Supreme Court says that, look here, this act will prevail over the Arbitration Act. These are small things, but it's so empowering for the person. कई बार लोगों को मालूम नहीं है इसके बारे में. मैं इसमें ज़्यादा कहने को, सबको मालूम है कि इस एक्ट में क्या लिखा है. लेकिन फ़र्ज़ कीजिए कोई एक, आप सप्लायर है हिंदुस्तान से, आपने यूएई में सप्लाई किया, आपको अवार्ड मिल गया. How will you enforce it? That's my biggest concern today. Enforcement of that. Because you're the supplier, the jurisdiction is here, from the supplier's place of work. How will you enforce that? That's where I think Tariq will speak about that. The other way around, India में तो पैसे जमा करना पड़ेगा उसको. These are a couple of issues which we will have to ponder over, but otherwise I think you people know what there is to be. इतना सारा कितना लिखा हुआ है, क्या पढ़ के बताऊँ आपको. But सच्चाई, at the end of the day, you know what arbitration is all about, how it is to be done. I'm giving you the figures that there's so much work to be done. Any economy whose money is delayed, this money of approximately 11 lakh crores should have been in the stream of commerce. That is pulling you back. Let me give you another figure. Just bear this in mind. This is only delayed payments. When on the bench, I had occasion to look at some cases about the recovery of monies. Let's put it very small, politely. The monies held up in those four fora was roughly 5 lakh crores for the last 7 to 10 years. पैसा ही नहीं निकल रहा है. Just imagine 5 lakh crores just in the Delhi region. कितना पैसा फंसा हुआ है. That money should have been in the stream of commerce. So there is so much scope for all of us to work in this arbitration field. Once the matter, I'll give you an example. The Facilitation Council referred a matter to the DIAC, came forward, and within no time the matter got resolved. Very often an arbitrator can see that this matter is resolvable. And at the back of the mind for the person who has to pay, he knows, that entity knows fully well, कि मेरा this 3 times the interest is there on my head, plus there'll be other costs, so we better settle it. Ordinarily it gets settled. Unless it's somebody who's a very aggressive type person, like the counsel Mr. Hussain spoke about, कि नहीं हम ही सच है, हम ही सही है. Here the law is with you. Here the law, and the lawyer has to just gently nudge the person, आप जरा रास्ते पे आ जाइए. That's the matter where it gets settled. Thank you very much.
Good afternoon, everyone, and welcome. On behalf of IIDRC, it is my privilege to moderate today's roundtable on cross-border dispute resolution as a competitive advantage for MSMEs. As we have heard Justice Wazeri say that MSMEs are the backbone of Indian economy. But when dispute arises, especially across border, they often struggle with cost, time, and enforceability. Rightly said. Today, our task is to discuss how arbitration and mediation can transform these challenges into opportunities. We have a distinguished panel with us, leaders from business, law firms, the bar, and the policy. Together, they bring the business view, the practitioner's perspective, the policymaker's insight, and the judicial angle. Before we start, just a small disclaimer. This discussion is meant for a wide variety of participants, as this is a camera-facing event. So while we are addressing these complex issues, we may simplify some aspects to ensure the conversation remains accessible and useful to all. With that, I would like to invite the panelists, and I would start with Mr. M.A. Johar, President, Strategic Business, CP+. Sir. Then I would like to invite Mr. Tariq Khan, Head of International Arbitration, M&CO Legal, UAE. Please, Mr. Tariq Khan. I would next like to invite Mr. Divyam Agarwal, Partner, J. Sagar Associates, to the podium. I would now like to invite Mr. Jyoti Kumar Chaudhary, Senior Partner, Hammurabi and Solomon Partners. Next, sir. Next, I would like to invite Mr. Zafar Khurshid, Partner, TKC Partners, LLP. Last but not least, I would like to invite Mr. Pragya Parijat Singh, Advocate on Record, Supreme Court of India. So, this topic that we have heard the special address on by Dr. Mahmood Hussain and from Mr. Justice Najmi Wazeri. So, the topic, I would like to begin this topic with the business perspective first. And I would like to know from Mr. M.A. Johar, as a leading business in India, what are the challenges, what are the factors and considerations are there a business deals with while dealing with a cross-border dispute?
Good evening. Thanks IIDRC for considering the business aspect with the legal one. So that's a great unity where we can see the future in India for arbitration and the law firms. I just take 1 minute on my experience right while I was working with the US multinationals and Indian companies who were doing business with or we were basically making agreements with the foreign companies for technology transfers and all. The major issue comes up with when we negotiate the MOUs and the agreements that where the arbitration would be. So nobody was basically trying for that it should be in India. It should be Singapore or European courts or Singapore courts or US laws. So things were drifting and all. The reason for this could be that we have to have, or we were not meeting their expectations of what you call it, the neutrality, which I could see, neutrality and independence, efficient administration. So those all are some of the unique things or some of the features or some of the expectations which corporate world has from the Indian dispute resolution centers, which were lacking, and I congratulate IIDRC that you have taken a step towards it, and then probably we will see that. So with these expectations is that the neutrality and is that you are not coming into any political pressure, you are not biased onto these things, as His Excellency Mr. Wazeri said that the special thing like the implementation of the arbitration in case of the cross-border corporates or cross-border arbitration. Now in that, how strong you are that you would be able to implement it onto the cross-borders. How fast you can give the judgment. How administratively you would be good enough to give the right kind of arbitration, right kind of expertise to the system or to the law-seeking people. The first and foremost, then the cost effectiveness of the system, the speed of the trials. So these are some of the things which are basically expected by a corporate world to have a right kind of arbitration in the right kind of atmosphere. So that is what we are looking at, and I think that would take on all of the challenges which Indian companies and the corporate entities coming to India are facing. And probably these kind of centers, if we will grow up and we will take on, then we will have good points to be on.
Certainly, Mr. Johar, those were really insightful comments on, and highlighting what the problems the corporate face and what the factors they consider while dealing with these issues. I would now like to move on to Mr. Tariq Khan. You have worked in both the jurisdiction in India and you are currently working in UAE. What are your, as Justice Wazeri also said, that there is an issue of enforceability. So please, your comments.
Thank you, Fahim. Am I audible to everybody? This one. Hello. Yeah. Thank you, Fahim. Thank you for your question. I think one of the issues we see a lot of MSMEs from India facing in the UAE, because there have been a lot of companies which are supplying. And I'll just tell you, last week I had a client who approached me from Hyderabad. They got a notice from one of the local entities from Ajman, and they asked us what needs to be done. We looked at the dispute resolution clause. The main contract had reference to US as the governing law. The general terms and condition had reference to DIAC/LCIA. So both these did not make sense, and clearly there was a conflict of clauses. And to give effect to such a pathological clause itself becomes a task, which means that you will never be able to give effect to a clause of this kind. What we did essentially is, because I told the client the risk, because MSMEs, like you said, they are the backbone of the economy, and they don't really want to become sick industries. If they're going to go to DIAC or to the US, they'll keep fighting and they'll never see the color of the money. And at the end of the day, the MSMEs are only interested in getting the money because they need the money to survive. They don't have, that kind of backing. So what we did for them, we essentially proposed mediation, because we knew if we try to invoke arbitration in such a case, it will be putting it on a back burner, like Mr. Johar was rightly saying. And that's where institutions such as IIDRC come into the picture, and why you all should, because business, they don't know when they are negotiating a contract. The only thing that matters to them is the financials, the commercials. Dispute resolution is, I think, the end, or probably because that's the honeymoon period for the parties, and they don't want to talk about how disputes will be resolved. So nobody really gives any weightage to the dispute resolution clause, and mostly it's a copy-paste job. And that's where I give this advice to a lot of institutions, give this advice to a lot of business. Just go to the website of the institution, say for instance IIDRC, you can just see their model clause, copy it, paste it. You can tweak it according to your own preference. If you're dealing with a UAE entity, they will obviously insist on using Dubai as a jurisdiction, and you have very little negotiation power because you want this contract and you really can't question. You know how it is. But what I suggest, you only ask for putting your own institution. Say that, okay, we will go ahead with Dubai as a seat, but so far as the institution is concerned, we will prefer IIDRC, and they will absolutely have no question. And that's where you will be able to control your whole case and dispute resolution, and you will not really have pathological clauses, because these institutions know their job, they know case management, and they will save you from a lot of trouble when your money is not going to be paid to you. This is going to be your saving grace. So I mean, this is one thing I want to say. The other thing I want to say is that a small enterprise from Delhi, they brought a judgment to me. They said that we want to enforce it. It's an Indian court judgment. What Justice Wazeri was rightly pointing, that becomes a problem sometimes. I took that judgment to DIFC courts. The DIFC courts has something very interesting, which is a conduit jurisdiction. Even with no connection to the matter, the DIFC judge recognized and enforced that judgment, and then we were able to tell our local team to then enforce it in the mainland court, and we got attachment orders. And if the other side would not have paid, it could lead to travel bans, etc. So Dubai is a very interesting jurisdiction when it comes to enforcing and recovering the money. So that's where we were able to put some pressure and get them to sit across the table and pay the money. So I think Dubai is a great jurisdiction for enforcement of Indian judgments as well. So that is something MSMEs should definitely explore.
That was really insightful, Mr. Tariq Khan. As you rightly said, that what I can gather from your comment is that a clause, a dispute resolution clause, a clear clause would help in the enforceability, and we have to see beforehand when we are dealing with the parties I think that's something you should take away, Mr. Johar. With that, I would like to move on to Mr. Divyam Agarwal, because he's dealing with these kind of matters currently. And please, your comments, Mr.
Hello. Am I audible? First of all, thank you so much to IIDRC, Fahim, for having me here. To Dr. Hussain, to Justice Wazeri, who's going to rejoin us very soon. First of all, so MSME, I don't think, while I appreciate there is a larger audience out there, and they would be keen to understand about MSME, but more the discussion right now is about how we marry it with arbitration, how we tie it up with cross-border disputes. So I will not delve too much into what is MSME provides for. I can possibly point out some gaps, and then I can tell you how it ties in with the institutional arbitrations, and then possibly suggest how a law firm like mine can come into picture to assist. So on the aspect of gaps, MSME right now, of course, it is one of the most well-intended acts to protect the voice of growing up companies, growing up firms who don't have that backing, that solid backing of finance that they can actually fight big battles. The act was intended to be a sort of a beneficial or a welfare legislation for these entities. The act itself recognized that a dispute resolution mechanism through arbitration, and they also promoted institutional arbitration as a part of one of the very unique acts, where the act itself talks about reference to an institutional arbitration through the council. However, it got limited only to, and I don't know what was the logic behind it, to micro and small enterprises. It was not taken to the medium one, while of course there are precedents that some of the medium enterprises also ended up using that clause. There's a Delhi High Court decision of Sterlite Industries where medium enterprises was also permitted to extend that benefit, but it somehow got left. So that was one gap which I identified. Then comes the issue that it's restricted to demand of payment or a delay in receiving dues. That's it. It is not so generalized, it's not so broad brushed that it covers any and other form of disputes as well. We also need to be cognizant of that right now in these industries and these growing companies, there is always a lot of complexity also involved. And sometimes the dispute is not just limited to the realm of recovery of dues. So it could have been a broad brush statement which allows parties to refer any and every kind of a dispute when they have a supply related issue. Then comes the next aspect of there is no cross-border dispute that is covered within that scope. As Tariq was pointing it out, that Dubai has these facilities, you can go ahead and invoke and enforce awards and judgments outside of UAE. The difficulty is that it's just limited to the fact that both the entities within the jurisdiction, the supplier here and the receiving party at any place in India, it is not extended to cross-border dispute. Maybe it would have make sense in 2006 when the act was introduced, because at that point of time it was not expected that MSMEs are going to transact globally, but that's not the reality anymore. We are looking at disputes across. I'm on a regular basis advising clients where there are MSME involved, there is a cross-border issue. I keep telling them to go for the inter se contractual dispute, but there are some useful provisions within the MSME, and they are not able to invoke those because of the cross-border nature of the dispute. So these are, first of all, the gaps which I have identified, which one needs to look at. Now, how it ties into an institutional arbitration and possibly how these gaps can help redress, the institutional arbitration can help redress these gaps. is what we should look at. Of course, institutional arbitration, as I pointed out, is been enshrined in the very act itself. There is authority given to the council to refer institutional arbitration, and the landscape over a period of time in the last, I would say, 5 years, 5 to 6 years, 7 years, have really improved. And in fact, Tariq is one of the front runners, used to be the front runners for that improvement in the domestic circuit of institutional arbitration. Similarly, your institute, IIDRC, again, and if I don't know if how many of you have looked at the arbitration rules, it's very interesting, you must look at it. It provides for all the, it has the same trappings which are there available in all big global institutions like ICC, SIAC and LCIA. You have an emergency arbitration, you have a fast track mode of conducting arbitration, all those benefits are there. So institutional arbitrations in India have really evolved over a period of time. There is a good institution like yours, MCI, DIAC and all those. So they have defined procedure. They have procedures which are globally accepted. So it is important that MSMEs are made aware of it. They appreciate that these institutions are there in existence. They can help streamlining the dispute itself. They can help in getting the right direction to the entire dispute, getting it resolved in a faster and a more efficient manner. And ultimately, it may even help in what Justice Wazeri pointed out on the enforcement issue. That is another aspect which can benefit out of an institutional rule just like yours. So keeping all these benefits of institution in mind, what a law firm like mine could do is possibly, first thing is about awareness, about training. Most of the MSMEs, and I have coincidentally a lot of friends who have over a period of time from micro to small to medium, they have evolved as enterprise. They are not savvy or well versed with what arbitration is going to do, what institutional arbitration is going to provide. MSME has certain stringent provisions which can actually help the cause of recovering of the dues. I'll give you one example. I was reached out by an entity, and they had a recovery of around 12 crore Indian rupees. We invoked MSME provisions, and MSME provision provides, and I'm sure audience is aware of it, there are penal interest prescribed. And that penal interest, when it was vigorously pursued and invoked, the other side actually came to the negotiating table within 2 to 3 weeks time. So there are, again, second thing, there is conciliation. It's a med-op kind of an approach prescribed in MSME. There is a conciliation there. If it is followed in a proper manner, then that really, the parties are not required to wait for the light at the end of the tunnel. They can very well achieve it at the first station itself. So that awareness is something which we all law firms, lawyers must provide, must educate everyone about. Then what we also need to assist is on the policy reform. I pointed out certain gaps. We law firms and lawyers, we must liaise with the policy department, bring it to their attention. What are these issues? What are these gaping holes which needs to be filled in, so as to ensure that it becomes even a more efficient system. And plus, we also need to give that practical training to the arbitrators, to the council, because most of the time what I've seen is the arbitrators who are there, they also are not so well versed with the practical way how the arbitration functions. So if you get good expertized arbitrators, you get good expertise conciliators, it's going to help to run the process in a more smoother and an efficient manner. So these are the gaps which can be fulfilled, and a law firm can play an important role in fulfilling those.
Absolutely, absolutely. Thank you for your comments, and I think you've raised some very interesting questions. The gaps that you've raised in the MSME Act and the practice that is there, and law firm can certainly, like, this discussion is a start where we can like discuss, create awareness regarding these points, and then the policy would follow. And with that, I would like to go on to Mr. Jyoti Kumar Chaudhary to shed some light on the policy change that can happen, and what points that have been raised by Mr. Agarwal. Sir.
Thank you, Fahim, and thank you IIDRC for having me here. I hope I'm audible. Since you asked about policy, let me give some practical aspects. So when we are talking about arbitration and ADR, ODR, all those things, look what we have done in the arbitration. We have taken out adjudicative process from the civil courts and put it in the framework known as arbitration. And the produce of that arbitration, when it comes in our hands as an arbitral award, we throw it back to the same CPC, civil court, for being executed as a decree of a court. Now, referring to what Dr. Hussain has also referred as a culture, civil court has a specific culture, civil court culture. Though it's very nostalgic to me, I started as a civil lawyer in the trial courts and all. But anyway, arbitration has a different mindset, different culture, different pain points, different urgencies than civil court culture. So, I mean, when we say arbitration is a complete code, Arbitration Conciliation Act, I think that's incomplete sentence. It will be complete when there is a framework for dealing with the arbitral award differently and in the manner what ancestral model law suggests, not as a decree under the CPC. So that's first regulatory or policy reform, I think, which is required for the purpose of this thing. Then coming to the MSME Act. If we see MSME Act, the structure, it is loaded in favor of supplier and against the purchaser, supplier or service provider. So whenever there is a person, I mean, when we are talking about cross-border transactions and all, there would be a restraint or there would be a deterrence in the minds of those who are outside in dealing with MSME, which is registered under this MSME Act. Because of these loading of provisions in favor of purchaser, and specifically section 15, when it says deemed acceptance and acceptance, there is a provision given to the purchaser to dispute the provision of service or the supply. And then we come to section 18. It says disputes, those disputes can be referred which relate to payment under section 17. So basically it is a dispute of payment. It is not the dispute with respect to providing of services or providing of quality of goods and all. That is specifically captured in the terms. So that gives a mindset. I think those reforms need be required to give more confidence to both the parties, both sides. I understand MSMEs play a very important role in our growing economy. Of course, as a supply chain provider and all, in many ways. So the security is necessary, but so far as arbitration is concerned, there is a requirement of balancing because arbitration requires that. So far as when we talk about cross-border, then there are certain mechanism of ODR, and I saw a certain rules like APEC rules or UNCITRAL technical note. UNCITRAL technical note refers to 3 stages. I mean, rather, it first says direct negotiation, then facilitated negotiation, and then third is the final one, which UNCITRAL doesn't say as to what would be that. APEC modality suggests first is the direct negotiation, then mediation, which is facilitated settlement, and then arbitration. What flaw I saw in that, which rather conflicts with our public policy, is this, that the same neutral who acts as a mediator continues to act as an arbitrator as well. So that is something, that is a flaw. So those, I think, reforms are required to give it more credence and enforceability, of course, in India as well. Thank you.
Thank you so much, Mr. Jyoti Kumar Chaudhary, for your insightful remarks. IIDRC as an institution, it's trying to play the role and it's trying to bring in the reforms and the changes that are required to better facilitate for MSMEs, because the cost and that's a big issue that MSMEs face, because in order to get something done in arbitration, a lot of expenses are required. So one, I feel, this is my addition, that we need to bring down the costs of these arbitration and mediation, and Schedule 4 of the Arbitration Act has tried to do the same. So I would now, with that comment, I would like to move on to Mr. Zafar Khurshid, and would like to know the practitioner's point of view of this thing, like how can we tackle this?
I think, my colleagues on the dais have already raised quite a few good points, but I think I'm going to keep the practitioner's view very, very hyper-focused on two aspects that we're here to discuss. One, MSMEs. Two, institutional arbitration. I do not think that India has delivered on the promise of institutional arbitration to date. We have, as my colleagues have said, we have some wonderful institutions. We have seen an amazing evolution of institutional arbitration. We do not have a culture of committing to the real promise of what institutional arbitration can offer. And what is the actual role of the institution in arbitration? We have these conferences regularly. We have practitioners from across India who attend them inside and outside India, and similar questions always come up. Why aren't we competing with LIAC? Why aren't we competing with Dubai? Why aren't we competing with Singapore? I mean, the closest approximate by people, why aren't we competing with Singapore? The Singapore International Arbitration Center is not afraid of holding its arbitrators to task. It does not rely on parties creating paper trails about what they think is going right or wrong in the arbitration for a 34 challenge later. They have a vested interest in ensuring that their arbitral disputes are timely and that their awards are enforceable. I'm not sure if everyone would be aware, but the award goes to the Secretariat for suggested editorial changes and even substantive review, because that's a vested interest that the institution has in ensuring that the award is enforceable. And that is a culture. That is an issue of culture. And that's a commitment that only comes when we start actually using institutions for the purpose that they're supposed to serve, and when institutions are not afraid to keep actually every stakeholder to task, whether it's the litigant, whether it's the counsel, or whether it's the arbitrator. I think that's a big part of it. And when that culture becomes pervasive, that is when we will finally see changes. That is when people will start appreciating institutional over ad hoc arbitration. That is when we will start appreciating specialized expert arbitrators over necessarily people with a judicial background, because judges have, they serve their entire careers and they have a knowledge base that most people can't compare. But if it's a really, really technical subject, is that necessarily the best person to be an arbitrator? These are all questions of culture. So as, of course, as Dr. Mahmood was saying, culture. But that culture plays a role at every part, not just culture of the individuals, but the culture of the infrastructure itself.
Rightly said, Mr. Zafar Khurshid. I think the culture, the traditional practice, the culture that we have of civil litigation and criminal litigation has also seeped into India, into the arbitration practice as well. And I think as different stakeholders, as business persons, they are here today, as firms, as individual practitioners, we need to have a little different perspective in order to compete. And as an institution, as an IIDRC also, the vision is to actually have that change in culture and you deliver to the common people as well. With that, I would like to move on to Ms. Pragya Parijat Singh, and your comments on the judicial side would be really appreciated.
Good evening and namaskar to one and all. My biggest support to this topic would be to not interfere. The biggest support from judiciary is to not interfere with these institutional arbitrations and mediations. So Justice Tejas Karya 2-3 days before made a remarkable statement that these are not alternative dispute resolutions as of now, but in fact independent pillars of justice. Now we need to understand we're talking about MSMEs, the vulnerable ones. There was a reason why government felt that there is a need to create a statute in 2006 to protect them. They are probably 110 million people who are involved in this particular sector, contributing to 30% of the GDP, probably second after the agrarian economy. So the chunk is large, but still they are vulnerable, they are destitute, because if they don't have money, they won't be able to survive. They'll become sick. So how do we come into the picture? We are from judiciary, so our support is to ensure that the law is correct, not misused. Whatever lacunas are there, we are able to fill it. And then at the same time, there are 2-3 very beautiful provisions which are entailed in this particular act. And especially the 2020 amendment has really made the statute more stronger in that regard. You're supposed to pay 3x of the amount in case if you do delayed payments by 45 days as per the prevalent RBI interest rate. Then other than that, it also says that even if you're not happy with the award or the decree or the order that has been passed, there is a provision that you can eventually go to the court. But that too, the court pushes you back by saying that if you have credibility, deposit 75% amount of it, and then we are going to hear you out. So all these ways or modalities by enforcing provisions like this clearly show and depicts that the court does have an intent to support them, but they need to be empowered, they need to be educated, and then only they'll be able to flourish. We are talking about MSMEs, we are talking about big things, but at the end of the day, last mile connectivity, vertical and horizontal approach, educating them is the only way out to my understanding. Thank you.
Absolutely, absolutely, Mr. Singh. And with that, we have heard the distinguished panel on different views regarding the same, and absolutely we need to work. This is just a start where we start up the discussion regarding MSMEs, because they are the ones who they face these issues, and we need to start the discord regarding making it better, making the system better, and that can only start with having this discussion. I hope I would come back to Mr. Johar after hearing the distinguished panel, because we are also short of time. DAW is starting and everyone has to go as well. So I'll just do a short Q&A after that. But Mr. Johar, after hearing the different perspective, what do you feel? Do you feel better now after hearing?
I'll just share my pain. I was doing a project which is a defense project. This is Network for Spectrum. Under 4G, when government telecom department has taken 4G from them, they committed army that will provide you a fiber-based network. I was with the HFCL heading the defense division, and the project worth about 3,000 crores, and we have got about 40 plus OEMs in that, and out of that about 23 foreign OEMs. Microsoft of the world, Oracle of the world, HP of the world, those kind of guys. And being the business head, we have to negotiate with them. And all other terms were okay, but everybody did not wanted that arbitration clause in India. So I think looking at this, that we are moving towards that kind of facilities, that kind of expectations, meeting the clients and all, we would be coming on that pain point would go off, and looking at that now we will have more clear terms onto that okay, we have the better facility than the Singapore. We can give you the arbitration awards which is enforceable, which is committed. The major thing is that no hidden cost. That is what is the major things from corporate side, that boss bata do ek baar kitna lagna hai, aage piche mat bolna. So that is what is that budget management and all those kind of stuff. So good to see and good to hear that we are moving towards that. Thank you.
Thank you so much. I would like to thank the panelists over here, and just one comment I would like to make. Dr. Mahmood Hussain had set today's evening's discussion with a very new perspective regarding the culture. And I think the panelists and everyone has carried on to that. And that's a very fresh perspective that has not been discussed. I don't think that has been discussed anywhere. And that's a very important aspect, that we need to imbibe these things in order to change, because the system will be changed. We have MSME Act, we have all those provisions, but it's us who need to change a bit in our approaches in order to better deliver to the businesses, because they are the backbone of we need to strong our backbone of the economy. And now with that, I would like to open up to the audience to questions. If anybody has any questions, they can state their name and ask questions. Yes, sir. Sure.
Hi, this is Faiz from SME Street. Amazing conversation, and since I'm representing the MSME sector, and I mainly interact with the MSME sector, having a limited interaction with the legal front. My observation based on the interactions that I had, again, it's very cultural, which Justice Wazeri mentioned. When it comes to these kind of arbitration or this kind of samadhan portal conversations are concerned, I have been part of some conversations, and I realized, and I also heard the same thing from some of the senior officials who were actually taking care of that the MSME delayed payment specifically, kind of conversations are like, or conflicts are like, husband-wife, conflicts going public. Is there a way we can, solve it, keeping this as a closed door kind of thing? One, is there a way of doing it through a kind of, proper SLAs at the beginning of, some contract or whatever?
I think anyone in the panel would like to take lead on that and answer. I think Mr. Tariq. Mr. Tariq, interesting fact, he is the author on a book on, I think we're having a technical glitch. Is it fine? Can we start now? Thank you. So Mr. Tariq, interesting fact that he is an author of an MSME book, and I think he'll be better equipped to answer this. Mr. Tariq.
It's working, yeah? Okay, thank you. Thank you, Fahim. And I'll just tell you how that book came up, because we were trying to write an article on MSME law, because a couple of landmark judgments where these issues of registration of supplier, the interest rate, 3 times the banking rate, all came up. And interestingly, if you will see the act, if you look at 15 onwards, 15, 16, which talks about the interest 3 times the banking rate, compounding interest, all of that uses the word supplier. Whereas if you look the definition of supplier in 2N, all over you will see the words micro or medium enterprise, small enterprise. Yeah. So Mr. Akhil Sibbal was against me in this matter before the chief court, where he was trying to explain to get the benefits of the MSME Act, which a lot of MSMEs don't know, and they got deprived by Shilpi Industries, which was a landmark judgment and still remains. They did not get themselves registered under the Udyam registration number. Because they were not registered, they could not take the benefits of the Act. And that was the argument that he was taking. Anyway, without commenting on that, your question was in relation to the conciliation part. So under section 18, which Divyam very rightly pointed, it's a 2-step mechanism, and a lot of MSMEs don't know. Part 1 is mandatory conciliation, which is not mediation, because India is a very interesting country where they have differentiated conciliation and mediation. But after the mediation bill, that distinction is gone now. So conciliation essentially is mediation, which is confidential, which happens. So I did matters of MSME in Kanpur, in Gujarat, in Bangalore, in Hyderabad. In fact, for the state of Hyderabad, I made that policy for all the MSMEs and all the officers who are dealing these matters to refer these matters to institutions such as IIDRC. And which is what happened, we took the whole burden of the state, because the state did not have the requisite infrastructure to deal with these kind of cases. And there's a time limit prescribed to finish this matter. Now, once that conciliation happens, it's all confidential, and that's your chance to resolve your family dispute, with your friend, with your business partner. Because the beauty about mediation is, and I need to convey this message, when you're putting your clauses, try using MEDARC clauses. And the beauty about MSME Act is, if you are a registered MSME entity, no matter what the contract says, no matter what it says, because Mr. Johar was saying that we don't have the bargaining power most of the times. Contract goes out of the window. The statute comes in. If you look at 24 of the MSMED Act, it says notwithstanding anything contained in any other law. Because two private parties, by an agreement with each other, cannot oust the law passed by the parliament. And this is a welfare legislation. So the law makes it mandatory that contract provisions will not apply. The provisions of the MSMED will apply. And that says mandatory conciliation first, which means you have the opportunity to resolve. Why resolve? Because the relationships will be there, protected. Mediation is the only mode of dispute resolution which is not adversarial. Litigation and arbitration will only, you will see the judgment in your hand, but relationships will be over. And that's why try your best to resolve the dispute then and there at the stage of conciliation. And mostly these councils which have been formed, and each state has its own rules. These councils will try their best, and they are usually pro-supplier. So they will try to tell the buyer, please resolve this, give the money. Otherwise, the interest will be, they literally tell them like this. And that's why this is a draconian law for the buyer. That's how they try to put it. And I think that is your chance to resolve. So I don't think there is anything else which is required. That provision is already there. One only needs to know, like Pragya rightly pointed, awareness, I think we all agreed, was the real culprit.
So yeah, awareness. So we are also working up with a lot of MSME organizations to spread this awareness. And rightly said, like mediation is going to preserve a lot of relationships, be it business or personal. And that is something the government of India is also pushing. Because we are short on time and everyone is busy, it's a working day, I'm going to take one last question. Anyone in the audience would like to address a question to the panel? Okay, so I see no hands being raised. So with that, sir.
We speak from experience that many a case which came up, we found two warring parties, often family members, and these go into maybe thousands of crores. I recall a matter, the first day I saw a bunch of lawyers this side, I calculated in my mind 70 lakh rupees. Then I looked this side, 65 odd lakh rupees. Oh, gama gami, chagda ho. All I did ask a question, simple question. Is it possible to do it in this manner? Suddenly there's pin drop silence. Yes, we'll come back. The next day, the number of lawyers reduced, and the matter went on for a few days. It came to almost to a situation of resolving it. Then the matter went away. The moment it went off my bench, I found that 4 cases more had started till it came back to me. This went on back and forth, and they were fighting tooth and nail because it concerned different jurisdictions in India and international also. Ultimately, that family found solution. All that the court had to see was be at it and showing that what you said, Tariq, at the end, what Mr. Mahmood said, keeping the relationship going. So the family, one family took all of India, one family took the entire world. So that's how you divided the market. It was brilliant. And they were masters at that particular game, that particular industry. So it's something I'm sharing with you. It's the lawyers, they have to be at it and find a solution. These are multi-billion-dollar industry units actually. So it's so it can work out so beautifully if you're at it. Agar dil saaf hai to sab kuch ho jayega. It's a question of what is your disposition towards the problem at hand. And the lawyers, I have found many number of counsel moved aside, and those who were actually the retainers, they were at it. Exchange of drafts for settlement. It happened, and it's the polite way. All that grandstanding got over in the first couple of hearings. But then what happened? You saved, these were virtually novel products which they were making in the industry. So they got captured, one to India, one to the rest of the world. So what Tariq said is the right thing. Solution बहुत आसान, especially in MSMEs, but virtually in the third hearing, third time is listed, the matter is resolved. Ordinarily, that's what happens.
If I may add something, I think another element to the culture is the psychology of arbitration. Because long historically, in my region, I'm speaking at least, was dominant with the male white people. So the council were white, the practitioner as well, they were white, and we didn't have. Now, slowly, we started to have people from continental India coming, Asian coming, Emirati started to come to that. The equation started to change. Now, the psychology started to change rapidly because we see expert now, engineer, accountant, they become arbitrator, they become counsel. We know some engineering, InShield, for example, they have background legal and engineering, and they become arbitrator, they become counsel. So basically, there is a psychology and we have to understand. Then another thing, I think what we are missing at that stage, we don't appreciate different jurisdiction. Common law lawyers want us to impose on us the way they do drafting, disclosure, for example, the hearing, the cross-examination, which is not. I think we have, as a lawyer, to give opportunity to learn and understand. It's a different legal system. We appreciate the strength we have. And we, other side, so basically each legal system, whether common law or civil law. But I have seen some lawyers comes without understanding the psychology of the people who are running the show and starting to cater that and cater the difference between civil law and Sharia law, for example, appreciating the good and strength in each one. Thank you very much.
Absolutely, I totally agree with Justice Najmi Wazeri and Mr. Dr. Mahmood Hussain. Dr. Mahmood Hussain, you said about that we need to understand the psychology, and that's why we understand that the institution is trying to recruit as trainers for mediators and arbitrators. In our module, there's going to be psychologists as well, training arbitrators and mediators, because unless and until we understand who we are catering to, where they're coming from, I don't think
I think
can't.
An institution, fundamentally, they have a problem where we come up issues, because most of the court were dominant by people from Europe. And now they started to realize there is a problematic issue. So basically, DIAC, it's a first time to put people from India. In like all the business, I would say 60% of the dispute has element of Indian, either Indian business in UAE or Indian business. But we didn't have in the court any Indian nationality. Now they started to realize that this is issues. This is fundamentally a flaw on the process. You need the culture, you need the psychology. So they appointed Hero Adwani as a court member in India. But this should have been like 30, 40 years ago. So basically, I think with having more counsels, collaboration between Indian counsels and Indian judges and lawyers with the UAE, we can learn a lot of jurisprudence has been evolved for 100 years in India, and we don't have this luxury. So basically, we can learn and build from there, where they finished the Indians.
Absolutely. So with that note, I would like to end this discussion and